Welcome to the module called Law of Treaties. I am Professor Malgorzata Fitzmaurice and I am a convener of this course. There is a perception that Law of Treaties are really not a very interesting part of international law. However, I would like to tell you that Law of Treaties is absolutely indispensable for everybody who is interested in theory but also practice. Law of Treaties is one of the sources of international law, which are enumerated in Article 38 of the Statute of the International Court of Justice. It is the most versatile source of international law. There are areas of international law, such as international environmental law, which are almost entirely regulated by treaties. The Law of Treaties is absolutely indispensable for anybody who wants to work in international organizations, in legal advisors' office of foreign offices, or if you like, ministries of foreign affairs, or for instance, United Nations. The Charter of United Nations is a treaty too. So knowledge of treaties will give you, if you are interested in work in public international law, a very valid and very solid background for your future work. I would also like to mention that if you are an international lawyer, you are a barrister or solicitor or a lawyer working in a big law firm, Law of Treaties is also one of the main areas, knowledge of which is necessary. A Law of Treaties is very complex. It's not only theory. Obviously, it has lots of practical issues. It's a living issue. All the areas which are regulated by treaties are subject to some rules of Law of Treaties. So, Law of Treaties also has relates on case law, so you will know a lot about international courts and tribunals, and of course, International Court of Justice. We include it in our study guide very extensively. So, how Law of Treaties is regulated? Well, we have 3 conventions on the Law of Treaties, and the most important and of fundamental importance, I would say, is 1969 Vienna Convention on the Law of Treaties. There is also Vienna Convention on succession of states in respect of treaties, and the Vienna Convention on treaties between states and international organizations and international organizations. However, nothing can surpass the importance of the 1969 Vienna Convention. Vienna Convention was codified by the International Law Commission, which is an organ of United Nations, specially established in order to codify and progressively develop international law. It was one of those subjects of codification, which is the most important success, along with articles on state responsibility of the International Law Commission. Vienna Convention is the basic document which all legal advisors rely on. It is used by the treaty section of the Secretariat of the United Nations. I cannot overstate the importance of the Vienna Convention. Of course, when you read particular provisions of the Vienna Convention, you only see rather succinctly formulated, you may even say in a dry manner formulated some provisions. But if you start studying the Law of Treaties and you see the practice of states and the case law of international courts and tribunals, you are aware that treaty is a living instrument, and the Vienna Convention gave the basis for some rules and regulations which now are developing further through practice of states, case law of international courts and tribunals, but also work of the International Law Commission. The International Law Commission had further very fundamental input in the development of our knowledge on the law of treaties. There is a draft on reservations, guidance for practitioners, which are result of 17 years of work of Professor Alain Pellet from France, who produced 17 reports of fundamental importance in understanding of the law of reservations to the treaties. There is now a project going on subsequent practice, which is very relevant, which is one of the context of interpretation of treaties, and also project on armed conflict and the law of treaties. So this is developing and very alive subject of international law. In fact, I can say in conclusion that there is no international lawyer without knowledge of the law of treaties. Treaties are also interacting with other sources of international law, like customary international law, which is also subject now of the work of the International Law Commission. So all this is very richly substantiated by the practice of states. Therefore, if you are interested in international law, there is no subject which is more international law than the law of treaties. Therefore, if you envisage practice as an international lawyer or a lawyer working with government in any country, I strongly recommend taking this module on law of treaties, because it will give you in-depth insight in treaties, which are fundamental for knowledge of international law. So it may look dry and maybe not interesting, but if you look into practice of states, it becomes a fascinating subject. Thank you.